Okay, morning everyone. Yep. Okay, morning everyone. We will continue with the last bit of cancellation as a setup then for next week, where we start to, or rather continue on with different ways that a contract can end, or the court says, or Parliament says that it should end. So that's kind of the theme you'll see throughout the semester. Cancellation is what can one party do to end a contract when another party does something. And next week when Marcus takes you for frustration, you'll see frustration is about what happens when something happens beyond the control of both parties that makes the contract untenable. But we'll talk now about the last two steps, and this is easy to conceptualize under the broad category of pre-cancellation and post-cancellation. Because step 1 to 3 are all about what happens before cancellation. Okay, so you need a valid ground of cancellation, one of the four, and then you need to assess whether or not there's been an affirmation or a decision to cancel. And then you need to determine whether or not appropriate notice has been given. And we finished talking about that on Monday. Remember how you need to either make known in the first instance to the breaching party, that is, some sort of communication to them, or if they either can't be contacted or they have disentitled themselves from being contacted, i.e. they've abandoned the contract, then you are allowed to have a more broad or general sort of communication to fulfill that requirement to cancel the contract. And that's kind of what the court will allow, or the Parliament will allow you to do in those circumstances, to kind of prevent the accusation that you didn't properly cancel the contract when you really did or you reasonably could. So that's kind of what will happen. So now we're assuming that all of these steps have been achieved, and we are now here. This is the point at which the contract is cancelled, once that notice is given. Okay? Before we move forward, does anyone have any questions about anything arising from last class about notice or affirmation? Cool. We'll now talk about, essentially, steps 4 and 5 are sort of two sides of the same coin. Step 4 is about what happens to the contract once you cancel, because that's important. You want to advise your client what is the effect going to be of this contract being cancelled. And then step 5 will talk about what can the court do to address these issues. So we'll start with the effect of cancellation, step 4, and it's really important that you have the statute, like you know the statute or the relevant sections well, because, as I said, they will keep you kind of from going off track. This particular section is 42, and it tells us two things, really. It's got two sub-branches in 42.1. 42.1a says if the contract is in any way unperformed, no obligation, there is no obligation on either party to continue performance. Okay? So on a timeline, it's best to view it as this. Anything after this point, there's no obligation to perform it. That's 42.1a. Okay? So that means that neither side can enforce on the other an obligation that arises after this point. This is why timing matters in cancellation. And 42.1b tells us what happens before cancellation. To the extent that the contract is performed, No party is by reason only of the cancellation divested of any property transferred or money paid under the contract. And what this means is this. If money or property has changed hands at any point here, it stays where it is. The cancellation does not shift ownership automatically. It just stays where it is. Yes, Lucy?
Ask about the diagram. So with the pre-cancellation, you have to make known that you're cancelling, right?
Yes?
And what's the right-hand bubble say?
A reasonable means. Yep. So, the property must stay where it is. Property and money. That's the general rule. The reason for that, or rather how that works, is that if there does need to be any changeover in the ownership of property that has changed hands during a contract, the court is the one that will do that. And we'll see that in section 43. But it's not going to happen at this stage yet. Yes, Lucy? Divested means like the property is taken away from you. Yep. Importantly though, remember that you have a common law right to seek damages in the event of breach, and also under the statute section 35 enables you to do that for misrepresentation. Well, none of this precludes that. You're still entitled to your right in damages. Okay, so that none of this removes your common law right to damages, your expectation interest. That's 42 subsection 3. Now that is reasonably simple, but it starts to get a little bit complex because the courts have indicated there are some exceptions to 42(1)(a), or they don't say exceptions, but they are in effect exceptions. One of them is logically this idea of the obligation to pay damages for breach under the common law. Okay? Remember photo production? You guys looked at that in first semester that introduced the concept of secondary obligations. One of those is the obligation to pay damages. And logically speaking, that obligation continues here. Because think about it this way, if there was no obligation to pay damages in the event of breach, what would be the utility of that? So the court says that in some instances there are secondary obligations like damages that may continue. We don't need to know the entire list. You can just cite damages. There's another one called restraint of trade. Does anybody know what a restraint of trade is? We'll study it in week 5, but does anybody know what it is? Anyone want to take a gamble? Yeah.
Is it like an injunction from, like, going off of the thing? Is it like an injunction from trading with a competitor?
Yeah. So it's colloquially referred to as a non-compete. And in an employment context, it often involves, say, particularly like a high-ranking executive employment agreement might say that if you work for our company, then 12 months following the termination of your contract, you're not allowed to work for a similar company in, I don't know, a 100-kilometer radius or something like that. And the reason for that is to protect the value of the business, so that you don't just go and devalue the business by taking all the secrets and the clients and that kind of thing. So that kind of obligation continues cancellation as well. So that can still be enforced by the employer, say if you breach the restraint, and we'll talk a lot about that in weeks 4 and 5. But the one we will spend most of our time on is this somewhat unclear one called the right to payment, which is already accrued, and that's in a case called Garrett and Ikeda. And this is where the timeline is important. So this case involved, again, a land purchase, pretty sizable land purchase. It was a quite large deposit of nearly $500,000, and the deposit was payable in 3 installments. Okay, so essentially, Mr. Garrett, the purchaser, keeps not paying this 3rd installment of the deposit. and Mr. Ikeda says, I need you to pay by the 17th of March, okay? This is it's of the essence. There's no issue that this is a breach, okay? So, finally, upon non-payment of the deposit, Mr. Ikeda cancels the contract, resells the property, gets more money out of it, and then sues Mr. Garrett, alleging that Mr. Ikeda is entitled to that unpaid 130K of a deposit. So the question is Mr. Ikeda entitled to that? It goes to the Court of Appeal, and I'll leave you to read the court's reasoning as to their interpretation of 42(1)(a) and (b), the equivalent in the old legislation. But they basically say this, that this deposit obligation arose, let's just say here, okay? And so ordinarily you might think, well, it's no longer enforceable post-cancellation, right? But the court says that because this deposit obligation, i.e. the obligation to pay the deposit, was unconditionally due at the time of the cancellation, that means that Mr. Ikeda didn't have to do anything else to be entitled to that. Therefore, that obligation survived cancellation, and Mr. Ikeda was able to claim that. It was unconditionally due because his entitlement to that did not depend on the transaction being completed. It had nothing to do with the final sale of the house occurring, of him giving the title and the keys, and to Mr. Garrett paying the whole amount. Nothing to do with that. And the reason the court said that it had nothing to do with that was because in New Zealand, there is an accepted business practice, particularly when it comes to sale of land, that if you purchase purchase land, often businesses as well, generally speaking, there's like an understanding of a 10% deposit that is non-refundable. So if the transaction falls through, you forfeit as the purchaser the right to the deposit. So the court says any deposit payment obligation that was unconditionally due. It had nothing to do with the transaction being completed. Mr. Ikeda needed to do nothing else to secure or receive that money. And therefore, even though the contract was cancelled, the obligation still continued and he could enforce it. Now, it's really important to note a couple of things. Number one, the court can still adjust that. So that's what the court said there in this extract, albeit subject to possible adjustment under Section 9, which is the equivalent of Section 43 today, which we'll get to shortly. So the court has a broad power to adjust any award. So even if Mr. Ikeda was at law entitled to the deposit, the court might still say, well, we should actually reduce that a little bit. We have the power to do that. I'm not saying they did that here or that it's relevant for us, but the court could do that. And number two, if the amount that is being claimed is greater than 10%, then the court may not regard that as an unconditionally due obligation. The reason is that the court might say that's not like a non-refundable deposit. That's part of the full that's part of the full payment that's due at the end of the transaction. Right? So actually, you still have an obligation to do something, i.e. complete the transaction to receive that money. And because the contract is at an end, then you can't enforce that obligation on them because it's not unconditional, because it's not a deposit. If the transaction fell through, you would be at an obligation to return the deposit to the purchaser. So you can cite this case, Simanka and Liu, for that. In that case, it was a deposit of $300,000 and a total purchase price of $650,000. So nearly 50% of the total purchase price. And the court there said, well, that's actually a part payment. It's not a non-refundable deposit. Okay? It's like a first installment, but it's not a non-refundable deposit, and therefore it's not an obligation that's unconditionally due. So if you want to, and I would actually recommend you reread paragraph 40 of Garrett, because it gives you the discussion of deposits in New Zealand, and it will tell you kind of what the accepted practice is. But the general big idea for you guys is, if there's like an unpaid amount that arose before the contract was cancelled, that unpaid amount could still be recoverable if it's an unconditionally due amount, like a deposit. Yes, Lucy?
When it says a rule subject to possible adjustment, what can be adjusted?
The entitlement of here Mr. Ikeda. So the amount that he's entitled to, the court could still adjust that potentially, which we'll discuss in step 5. But that's but the starting point is he is entitled to that unpaid deposit, even though the contract has already been cancelled. Questions so far? Anything? Anyone want to ask anything? Cool. Now, I've just included an extract here from the textbook that is critical of this approach. They think that it's a bit of a dubious statutory interpretation, but it is the law, so we'll go with that. So that is unconditionally due obligations, and then money, property, and land. Money, personal property, and land. So the big idea is that they all stay where they are until the court changes things. You've got a couple of examples here from case law about money. And note, in those cases, the courts could have changed ownership of the money at issue, but they decided not to. And so this is an important point. The court has the discretion to make property transfer orders, but it does not have to do that. Okay? This is, skipping ahead a little, this is different from what you learned in first semester. In first semester, you learned that where there's a breach, the aggrieved party is entitled to the expectation interest by right. Court is not allowed to interfere with that. Here, though, we're going to see that the court is allowed to interfere and does interfere with that. So, so that's kind of the tension that we're going to explore. Land as well. The court is not going to order the transfer of land. You don't need to know what an equitable interest or a caveat is. You will learn that in equity and land law. But essentially, it means that the land stays with who owns it until the court makes an order of sort of anything different. This case, Young and Hunt, is an illustration of the personal property point, that it stays where it is, and it's also an illustration of the court's discretion. So what happened here was a sale of a business, I think it was like a cafe or something, and the business contract has a warranty that says that the turnover was at least $600 per week, okay, for the last 4 months. And that's reasonably common. It's designed to give purchasers assurance that the business has been performing at a certain quality or certain level for a period of time. Mr. Young is the purchaser, takes possession of the business and soon realizes, well, actually, maybe that figure wasn't quite right. The books might say something different. So he finds out it isn't, and he cancels the contract. Miss Hunt, the vendor, says that that was an innocent misrepresentation, so you don't have the right to cancel the contract, right? Miss Hunt then cancels the contract and seeks the difference between the sale price and the contract price, because she essentially had to resell the business. And the court says that Mr. Young did not have a right to cancel the contract because he didn't have a valid ground. The misrepresentation wasn't of an essential, the warranty wasn't an essential term. Okay? So the fact that it wasn't $600 a week, that wasn't a big deal. Wasn't a big enough deal. And the substantial reduction in the benefit wasn't made out either. There wasn't a substantial alteration in the bargain here. So this is a good illustration of a case where neither of those grounds can be made out. You might think that, oh, you're always going to make out one of those grounds, but Young and Hunt is an illustration that sometimes you can make out neither. And that's perfectly fine. You can just say that there's no essential term or representation here that's been made out, nor is there a substantial alteration of the bargain. Yes, Lucy?
May I please ask what turnover is?
Turnover is like how much the business earns. Yeah. So what this means is that Mr. Young's purported cancellation of the contract is actually a repudiation. Okay, so and Ms. Hunt does have the right as the vendor to cancel the contract. She does cancel the contract. And the question then becomes, what happens to the stuff inside the building? So not like the actual building itself, but like say the industrial grade dishwasher, or like say the kettles or whatever else is in there. And the court says that because this is following the cancellation, it stays with the purchaser, Mr. Young, ownership. That's the starting point. It stays there. Just because of the cancellation, it does not divest him of that property. It doesn't take that property away from him. Okay? So that is all that Young and Hunt gives you. It gives you an illustration of the personal property staying where it is. However, it also gives a good illustration of where the court's discretion comes in, which we'll talk about in step 5. It's the idea that in this case, Mr. Young had to pay liquidated damages, right? So they had already agreed in the contract, but the court found some of that penal, and so it appears the court did some sort of calculations and said, well, he's already paid this much, so even though he's in the wrong, the final net value will actually involve the vendor paying him back $5,000. So that's an illustration of the court having a broad discretion to make the award it considers just in the circumstances. But it's also an illustration of how the court appears to have exercised its wide discretion to retransfer the ownership of that property back to the vendor. So the court says that's what's just. We needed to transfer the property ownership of the personal property back to the vendor. And so Young and Hunt tells us that the court will leave the property, or the starting point is the personal property stays with the person who had it, right? Following before cancellation. But if the court considers just, then it can switch that ownership over. So really, with the effect of cancellation, you just want to ask a couple of things, right? Number one, you want to ask, does anything survive cancellation in terms of obligations? Does either party have to be worried about the other enforcing an obligation on them? Because anything that arises after the cancellation won't be enforceable. But in some limited circumstances, obligations that arose before the cancellation may be enforceable if they were unconditionally due, i.e. there was nothing that the enforcing party needed to do to be entitled to receive that. So most likely going to be like a deposit, a non-refundable deposit. And then you want to ask yourself, what is the breakdown of the property as it stands? Who owns what? It's kind of just like listing who owns, I don't know, the car, who owns the house, who owns this, so because it stays where it is at the time of the cancellation. The cancellation doesn't change anything. Because then you can tell the court, okay, well, this is where the property is, and this is what we think needs to happen in terms of changing over ownership or possession of the property. Okay, so that's what the effect of cancellation is. Cancellation removes pretty much every obligation post-cancellation, and cancellation doesn't have anything to do with property ownership. Only the court will do that. Cool. Questions before we move on to the remedies part? Yes?
Just what you said about the space where it is, the personal property.
Yes?
Is it physically where it is, or does it matter, what's the title of those personal property?
Good question. Both. The 42(1)(b) is a negative provision, right? It says cancellation doesn't do anything. So if ownership, like legal ownership, has changed hands, right, already, then cancellation won't change the legal ownership. Possession, and you'll learn this in property law, possession can give you a right as against other parties. So, but we're mainly concerned with ownership or title. Yeah. Yes. Yeah, so we are sort of talking about remedies already because of Young and Hunt goes there. But now we'll go into remedies in full. Yeah. So we'll go to now. Remedies is what the court can do if there's been a cancellation. What orders should the court make, if any? And the big idea is that Section 43 gives the court a wide discretion to make the order that it considers to be just and practicable. That's kind of it by way of threshold. The orders are obviously monetary, and it can also involve the transfer of property, and it can also involve being like injunctive, so telling people to stop doing something, or telling someone to do something. So in effect, like similar to injunctions and specific performance. So very broad discretion, okay? The second dot point is about who can apply for it. For our purposes, just focus on the contracting parties. I've just included those other ones because the statute is there, but really we're only focused on the contracting parties. And the third dot point is about how this award under 43 is not a substitute for your right to damages under the common law. You are still entitled to whatever the common law would give you via the expectation interest. That is your right. Okay? The court is not going to touch that, but the court can offset any can offset the two and essentially stop you double dipping. Is what 49 is telling you. Right? The court's not going to say, oh, you are entitled to your claim in common law damages, and also we're going to give you the same amount under Section 43. They're not two discrete things that the court has the power to say, actually, no, you're not entitled to double dip. So this is quite tricky because the big idea, the most important thing to note is that, remember in first semester, there's quite a set way to calculate what you're entitled to under the expectation interest, right? You guys spent quite a lot of time with that. Well, surprise, the court does not have to follow that. And that's from a case called Newman's Tours. And it says the court is freed from the rigidity of established common law rules relating to damages governing such matters as accepted head of damages, remoteness, mitigation, and contributory negligence. No more. Obviously, common law damages you're still entitled to, but if you're talking about Section 43, gone. Right? You don't talk about, you can talk about those principles. You can apply them, absolutely. And in a lot of cases, the court will do so, but it is not bound to do so under Section 43. It can make whatever order it thinks is just and practicable. So that's now up to you to argue why do you think this award, financial or property or whatever, is just and practicable in the circumstances. So that's a very different approach to what you learn in the first semester, because it's much more subjective. It's not predictable at all. We don't know what any court will decide under Section 43, like we might do by being able to look back at prior cases involving common law damages awards. We could probably do some predictions, but it's very circumstantial, very fact dependent. Now, there are still some guardrails. Okay, number one, as a general, the object of relief under Section 9, which is the old Section 43, should be to compensate for loss caused by the cancellation, not to produce a windfall. So it's still compensatory, right? It is not just to give parties money willy-nilly. It is compensating them for the loss that they have suffered as a result of the breach or misrepresentation, etc. There are also principles. Sorry, Lucy, did you have a question?
Do you mean if someone cancels on you, then you have a choice, either a statute remedy or you can choose the common law remedy, but you can pay, right?
You're entitled to the common law remedies, and the court, you can ask the court to exercise its discretion for more under Section 43 if you think appropriate, but the court has the discretion to decide what to do in that instance. So, yeah. So it is compensatory, number one, and also number two, it is dependent on what is in Section 45. So the court must consider all of these factors in assessing what is the just and practicable award to give. These include the terms of the contract, the extent of the performance, how much was the contract performed, the court's opinion of any value of the services performed to date, any benefit any party got, and also that very broad criteria, any other matters that the court thinks proper. That basically means the court can take into account anything in the facts at all to ascertain what should be the appropriate award, but they must consider things like the terms of the contract, the benefit, etc. Okay? So practically, for your purposes, when you're considering the application of Section 43 to any scenarios or fact problems or anything like that, you just need to argue what do you think is just with reference to these factors in Section 45. Okay? You might just say expectation interest is just, but you still need to explain it by reference to these factors. That last dot point I've just put there for your reference because in this case, Newman's Tours, the Justice Fisher did list out a whole bunch of principles for applying that discretion beyond what's in Section 45. Those are quite lengthy and complicated, right? And they are still important and they likely will be of relevance, especially if you're writing submissions to a court. You should use those. For our purposes, though, I'm content for you to just to know that they're there and then focus your attention on is it just and practicable and according to the threshold matters in Section 45. Okay, so I'm just sort of giving you what the court has said in Newman's Tours, but you don't need to know those at page 97 to 98. Can be helpful, and I think it's helpful to read those, but you don't need to. I should say there's also a really important thing about Section 43 that's different from common law damages. Common law damages are only given to the party who is injured, right? Not the one who breached the contract. That's what you guys learned. But Section 43 allows the court to make awards to both parties. So even if one party breached the contract, in some instances, the court might say, well, you're entitled to something. And in some instances, the court could say, well, yes, you are entitled to your common law damages. Like say a renovation takes place and the contractual relationship breaks down, there is a clear repudiation, etc., and the expectation interest is, or there's a clear breach and the expectation interest is, let's say, $50,000, right? That's what you're entitled to at the common law. But under Section 43, the court might say, I know you're entitled to $50,000, but we think that the builder deserves something as well. So we to some sort of credit for that. So we are going to effectively reduce the net compensation that you're receiving by crediting for the builder's contribution to the house and the benefit that you still got, and therefore your net benefit is going to be, I don't know, let's just say $40,000. It's like a $10,000 credit. So the court can do that, and we'll see how they do that. Yes, Lucy.
I'm so confused. So if I cancel on you, how come I can still get something when I was the one to cancel on you?
If you cancel on someone, you have a ground of cancellation, and so theoretically you're wanting some compensation for the actions of the party who breached or repudiated or misrepresented. But what 43 is saying is that the court is allowed to give money or property transfer orders or whatever it wants to both parties. It doesn't have to just give it to one. It can do anything it wants, pretty much. That's just the big idea. As long as it considers it's just. Now, the other guardrail is that property transfer orders cannot be made if the property has been sold to another person who bought it in good faith, who is not party to the contract. This typically, this could, for example, be in another renovation situation if I am renovating your house and the purchase price is like, say, $100,000 plus your SUV, which is worth, say, $50,000. And you say, okay, I'll give you the SUV first, then I'll pay you the $100,000 at the end of the job. I take the SUV and then I sell the SUV to my friend Adam. And Adam purchases the SUV for, let's just say, I don't know, $35,000 from me. Adam has no idea of anything more than just an SUV. If the contract between you and me breaks down and it gets cancelled, the court is not allowed to make an order telling Adam he must give the car back, because Section 46 says that Adam is a person in good faith who acquired the property in good faith and for valuable consideration. So if Adam had been a bit dodgy or known that there was something dodgy going on, or if Adam had if I just gifted the car to Adam, it's a different story. The court can make the order. But if Adam's bought the car and there's no issue there, then the car stays with Adam. So that's one of the only sort of constraints on this power. 47 you can ignore. It's a quite weird provision that there's only ever been really one case that I could find on it, and it's not very clear. So for all intents and purposes, we can ignore what it means for a party to alter their position. But yeah, so basically the idea is that the court has a broad discretion to do what it considers just in the circumstances, just and practicable. So it must be doable as well. That's constrained by, number one, it's compensatory, right? The goal of Section 43. Number two, they need to consider the factors under Section 45. And number 3, they can't make property orders if the property has gone to someone else outside the contract who bought it in good faith. But outside that, go for your life. Now, I found this illustration that I thought was really good of how this is applied in practice. So what you have here is a purchase of a house with the intention of relocating it to Katikati from Remuera. And so the purchasers engaged this company, Uplifting Homes, to uplift the house and take it to Katikati and install it in their plot of land in Katikati, because they want to live there, they want to move out of town, right? They were not happy with the work that was done. There was, when they got there, like the plumbing wasn't put on properly, or that kind of thing, just wasn't connected in as much as they wanted to. They eventually seek about $365,000 in damages for breach of contract, and down from about 1.6 million actually. They eventually, because the house is not put on properly or not put on to the degree that they want, they have to sell the land and move to Nelson. So they've obviously incurred losses there. And Uplifting says, well, no, we didn't have to make the house fit for occupation. We fulfilled our obligation, which is to reset it on its permanent foundations and ensure its structural soundness. We did that. Like, we don't know why you guys are complaining. That's kind of the argument. And they argued that the purchasers caused some of the damage. Now, the court does find a breach of the obligations, right? So Uplifting Homes did in some way fail to put the house in like they said they would. The question is, what is the remedy that the court should give under Section 43? And this is a good illustration of how the court uses those factors. Because it looks at the terms of the contract, the fact that there was no evidence that Uplifting was not going to perform the contract, right? So they were doing things in good faith. They were trying to do their job. The expenditure of money by the purchasers, but also the corresponding fact that the work had no value as the house was destroyed, the fact that neither party got really any benefit or advantage over the other. But all of those factors went into this decision of how do we exercise the discretion. And then there was a claim for about $35,000 of economic damages, right? Economic damages involve, basically like distress that the purchasers felt because they were like, oh, we can't live in our house. The court was like, yeah, but you had quite unrealistic expectations about what would happen when you put the house in terms of when you could move in, what kind of incidental damage there would be, etc. And also, Uplifting actually did try to go above and beyond the contract to try and help the purchasers. So they didn't just leave it there, they were actually trying to help them, right? There was still a breach, but they tried to help them. Yes, Lucy?
So do you mean economic or emotional damages?
Emotional. Yeah. There were both, but yes, emotional damages claimed as well. So, put all of that into the pot and the court comes up with a decision. The just and practicable relief to which the purchasers are entitled must recognize also the company's legitimate and compliant expenditure under the contract, and they reduce the amount by 50%. So that is your that's your tension with your common law damages, right? Like, yes, you're entitled to this under expectation interest, but the court's like, sorry, we are reducing that. It's a 50% discount. The final damages was about nearly $95,000, and the big idea is that, yes, you're entitled to compensation, but actually you contributed and you bore the risk, and actually it's, you're partially responsible, and actually the company went above and beyond. So all of those things factored into why there weren't as much damages as they were entitled to. So this case is just an illustration of how you apply the factors to the facts to reach an outcome of what is just in the circumstances. Okay? Really good illustration, but just an illustration. Ultimately, if you have a situation that involves the application of Section 43, then it's up to you to argue on the facts. What do you think is just and practicable in the circumstances? And deeply engage with the facts, use Section 45, and then come up with an outcome. And different people will come up with different outcomes, perfectly fine. We could not predict what the courts would do. So that's what you have to do. All right. Now that brings us to the end. Let me just remind you that anything including damages or remedies can be modified by a contractual provision. So the court's discretion under Section 43 could be reduced depending on the scope of the contract. So you want to ask yourself, is the contract specifying that the court no longer has power to grant remedies, which would be perfectly fine, that grants certainty to the parties? Or is it saying that there's a contractual means for remedies, i.e. liquidated damages, but that the court's power is, or discretion to grant more or less is also preserved? So that's kind of the big idea, just to finish off. Yes, Lucy.
Question, you know how you said to grant remedies it has to be just and
Practicable.
what does practicable mean?
Doable. The order must be doable. Like the property must be able to be transferred, for example. All right. Give me 2 minutes before we finish up. Tutorials next week. Please go to them. There will be tutorial problems up on Canvas. Your tutors will help you work through these principles as we look at a couple of cancellation scenarios. Next week, Marcus will be here, so I'm not sure when he's going to upload the slides, but you'll get to meet him. Marcus is fantastic. He'll start you on frustration, and then we'll come back and tackle illegal and void contracts, which is another way that the court has massive power and discretion. All right. I will see you guys in 2 weeks' time. Yes. It depends on what the contract says, but yes. Yeah. Yes. Yeah, only about that. Yeah, so that was essentially a cancellation of the moving contract. Yeah, so that will also.
Just to clarify that Section 43
Yes.
it's kind of a
Yes, pretty much. Yeah. Hey, boss.
Just real quick, so with property, I didn't quite get what you were saying. So you said that in cancellation property stay was shut. And then what did that other thing say? What about? Talking about like property standards.
Oh yeah, then the court can change that. The court can change property ownership.
Okay, and then you said for Section 43, you said that it applies to both parties. Is that stated somewhere?
That's in the section. Yeah. So if you go to the act, you see that it's not restricted to the owners. But typically it won't be the business, but it's just the court can if it wants to.
Like an order to grant parties more property. both parties, right?
Yeah, both bodies.
And then you said for section 47, we don't really need to worry about.
Yeah, don't worry about it. Don't worry about it.
Last question, with like the damages you said before, how is that not different to common law? Like if you're saying
Yeah.
with mitigation and stuff,
Yeah, yeah.
is that not the same?
Similar. So the court usually will like say, one second. The court will usually say
Perfect. You've got a choice of 4 power
Oh,
points.
wonderful. Oh, you already got everything. Oh, that's wonderful. Thank you.
No worries.
Okay.
Got here early, so I was like, might as well just sit up for you.
Yeah, yeah, absolutely. Thank you so much.